Hey, Trish.
Hey, Isabel, Danielle.
So, Trish.
No.
A lot of things are really just impressing for.
Yeah, I feel like that a little bit too. Like, they just have one of these for like, homeless people.
Yeah.
One especially for that, one especially for that.
You know? Did you see the babe that bought like $200,000 in tickets? And I was like, come on, man, you don't need this.
$200,000.
I would too, because I mean, I would just, if I had it to.
Well, there's a,
That's not fair.
you're a math person, right?
Yes.
Supposedly, like, if it reaches a certain number, I don't know what the number is, I think it's less than 1.6 billion, that you can actually pick out all the, the combinations of numbers for like whatever, say it's 100 million, not 200 million. But who has that money to lay out?
Right.
And if you have that much money to lay out, you don't need 1.6. You know what I'm saying? It's stupid.
I think if I had 200,000 just to throw down the drain, maybe I'd promoted that. But if I had 200,000 to throw down the drain, that would mean I'd have a lot of money
That's
already.
good, right, exactly.
So then I'd do it. But now it's like, am I gonna waste time? Even $100, I guess, it's like it's not worth it because I know I'm not gonna win. You have a better chance of like flipping a quarter and it landing on the same face like 28 times in a row. You have a better chance of that happening.
Oh, wow.
It's crazy.
What kind of computers do you guys have? I'm buying a computer and I just cannot pull the trigger. Mac, oh, I'm not a Mac person. Well, don't ask the wrong people.
Mm-hmm.
I know Mac's great. My brother's Mac and he's.
See, I used to be PC like all the way, Toshiba and HPs. I was always so against Mac, and then I learned how to use my roommates in college, and I was like, Macs are just superior.
I know they are. I just don't know how to use it.
You can learn. It's really easy. It's all about the number of fingers you use on the pad.
Oh,
You can have 2 different functions for using 2 fingers, different for 3, and then different for 4, and then that's it.
Oh,
It's easy. Yeah.
One time I told my brother, I go, why? I do not use an iPhone. It's a similar operating system, right? I was like, it's so different. Don't get a Mac because you don't need that pressure of learning.
It's just playing with it to you. You know what I mean? That's my grandparents finally got smartphones, and I find that they're afraid to break it, and they have to realize that they're not going to break it. You can touch and click whatever you want. You're not going to break the machine. And the only way you learn is by clicking on everything and touching everything and figuring out how it works.
That's true.
So take that for what you will.
Yeah.
I think it's just so much better because if you close your laptop, if you close a PC, if you open it back up, you have to wait for it to start back up. With a MacBook, you just open it and go. And to me, that's invaluable because it's time saved.
And also just, I went to Best Buy last night, right? And I'm ready to pull the triggers, but I got approved for like the financing because like everybody's like, don't get a $400 computer because it's got the HDD, which is the SSD, all this other stuff, right? You're gonna have to spend like $700 on your computer, $800. So I'm like, all right. So I pick out. I thought I'm there tonight. I pick it out, and it doesn't have. It won't be in stock for a couple days. I don't have a couple days. I gotta take the exams off. Anywho, it's a 13-inch, right? Which is what this is. It's my work computer. I can't use it. It's only this, because I go in the terminal. So, hey, Professor Noah.
What's going on in here?
I was just chit-chatting about computers.
Computers?
Yeah.
Is it a small screen or 15-inch, 13 or 15?
It's all preferential. I had a 13.
Yeah.
I'm not sure if it's a 13 or 15. Let me check.
The good thing about Macs is they never get viruses either, so they last forever.
Oh, really?
Nope. How long do you have that as though?
Since before my senior year of high school.
Oh my God.
Yeah. And that's how I survived all of college.
If you're already gonna spend $700-800, you might as well kick in the extra couple hundred to get a Mac because it will last you 10 years at least.
Really?
Yeah, so it's been 6 going on 7 years.
Wow.
Yeah, it's a 13-inch.
And it works really well.
Really? It's okay, I mean, it's big enough.
Yeah.
And you know, I noticed I love throwing this, because I have that Toshiba, which is like 15 inches heavy, you know, and it's really nice to throw this thing in the book bag, right?
Yeah, and you just, I don't know, with Windows, they just get slower over time because more stuff gets put on them. With these, they just don't. It's weird. I don't know.
Huh.
I'm just a Mac person now, so I'm just going Mac.
And I bet you once you have gone to Mac or from a PC, you never go to a PC again.
That's right.
Right.
I will never go to a PC again, just because, I mean, the price differential, if you're gonna get a good PC, you're gonna spend $700-800.
Yeah.
I spent $1,100 on my Mac.
Really? It's not much more.
No, it's not that much more, and for the life of the computer you get out of it, and all the pros and everything, and the fact that it's not gonna get riddled with viruses and all the rest of it, you know.
What kind is it, Mac what?
I have a MacBook Pro, but you can get a MacBook Air. The only reason I got the MacBook Pro was just in case that it had a little bit more memory and it had stuff like software for if I want to like edit videos and stuff, and not that I need that at all because I'll never use it, but
And then the CD.
I don't know the CD.
Oh, you don't have it? Does the Air have a CD?
Yeah. They have the baby bars today.
Oh, yeah.
You guys are all smiling.
I feel their pain.
I feel their pain too.
Well, they're done by now, so.
They said that there, I tested them and they said there were 2 crimes.
Do homicide shooting.
Shooting?
So,
Was it during 2 dead bodies during a robbery and then a dead body during a ex-lover and current lover?
so I had not advertised this because I'm a professor, and I'm a lawyer for 20 years. I took a bar exam this summer, and
You did it just for the heck of it?
I did, well, not for the heck of it.
Oh.
My wife and I had traveled and we had decided on some places that we may want to retire to someday, you know, with better tax situations and whatnot. And there's one state that's on our list, Nevada, that is just like California. You want to practice in Nevada, you got to take Nevada's bar. No ways around it. And so I took it this summer and passed. I got sworn in on Friday. They're on a little different schedule. Yeah. So I hadn't said anything, and if I had not passed, probably a bunch of people wouldn't even know I'd taken one. But I could share that now, and it was it broke very good for me as well. There was an evidence essay, there was a criminal criminal law essay. The performance test was a homicide case to write a motion for new trial on a homicide case, and
I just love it.
It was almost stable.
yeah, and I told my wife, oh, you know what, if I don't pass this one, it's never gonna line up for me as nice as this one did. So I was fortunate, and it's weird though. I went up last Friday, to get sworn in, and only like 130 people passed in the whole state, the whole state of Nevada. It's like 57%, so like maybe like 200 and some odd took it. And the whole Supreme Court was there at the swearing in, and they had like the president from the state bar spoke, and the president from the local bar spoke. The Speaker of the House for Nevada's Assembly was there, and I wasn't impressed with any of them. Like, none of the speeches were good. None of them. And I just look at like our little world here with our professors. I'm like, God, we're head and shoulders against all these people right here. And maybe it's just a different world, and that was my first impression. I'm like, none of you can give a good speech in the whole group. But it was just a very different world.
Interesting.
So
I guess we're spoiled over here.
I think so. I just, I think about the people who have the lectures I've heard here and the guest speakers that have come here. And, there's a lot of talent just here in our little desert community. And I saw none of that on display. And a whole bunch of white men. Like they were all white men in Nevada. A bunch of old, grumpy white men. And I'm like, okay, so this is what we get. But our group wasn't quite as old and white. It was more of a diverse group, but I was the old guy there.
What's the big law school there?
Boyd Law. It's part of UNLV, the only law school in Nevada. It's Boyd Law School.
Wow.
So they had a speaker there too. Their dean spoke. And I'm like, nothing like Dean Dolan. He wouldn't have been up there giving a speech like she was. Just wasn't impressed.
So the 200 some, the majority of those were from that one law school?
No. A lot of people from outside here.
Oh.
There's a lot of Californians who take the Nevada bar because they can't pass the California bar, so they go to Nevada. And,
I thought you had to be a practicing attorney for 5 years before you took another state's bar.
Depends where you go.
If you go
really?
to an ABA accredited school,
Okay.
you can take a bar anywhere in the country. So,
If this school becomes ABA accredited, are you grandfathered in on that?
I don't know that. I don't know if
I
you
think the school is going right now for state accreditation.
Yeah.
Because there's unaccredited, there's state accredited, and there's ABA accredited. So I think they're still a long way from ABA.
Yeah, we're a long way from ABA accredited.
Yeah.
But if you are ABA accredited, you can go anywhere in the country. So
States just have different rules. Like I know there are some states that are like reciprocal states with like DC, for example. So you can go to DC after you meet the requirements here to sit the bar there, and then if it's a reciprocal state with DC, you can then take another bar. So you
right,
don't have to-
and that's kind of why I took Nevada's. Is I have a way in at any other state I want to go to without taking a bar. Right, I can go through DC and through reciprocity, I can get into others. Just it's more a pain of going through the application process and paying everybody's fees. But I had a way in. Nevada was the only one that if I want to be licensed, I got to take it. I'm like, well, just do it, get it out of the way. Never take another bar exam again. So
How many days was it?
3. Yeah. I'm like, of course, theirs is 3, now that California's is down to 2. But it's surprising. I joke. I say that like Californians who can't pass go to Nevada. Consistently, if you look at the list of like the most difficult bar exams, Nevada's is top 5. It's usually California, Nevada, New York, Louisiana, right, with their Napoleonic law, and so it's it was a tough one, but
Great.
got through it.
Don't move.
It's funny, we got, the results were supposed to be posted on like, I don't know, Wednesday at like 3 p.m. And so my wife said, hey, as soon as you find out, text me. I'm like, all right. So I'm on the website, I'm refreshing it, and, nothing's posted. And about 2:55, one of the partners at my firm said, Pete, I got a conference call at 3 and I need you in there. I told my wife, I said, hey, I'm going in for a conference call right now. You're going to need to check and just shoot me a text. And of course, she decides it's time to play jokes. Right. Right. She wants to play jokes and, I'm sorry, babe. You'll get it next time. Just choke her out.
And were you in the meeting?
I was in the meeting, I'm getting her text.
And how soon after that did she tell you the real thing?
Probably about 4 texts in. She decided to let me out.
And what did you do then when you yourself?
Nothing. I just saw it and I stayed quiet because I'm still.
Oh, that's right.
No, the firm didn't know. The firm didn't know I had taken it, and so I was kind of waiting. And they all had the same reaction as soon as they heard I passed. Are you leaving? You're not leaving, are you? Oh, I'm not leaving. Oh, okay. And then all of a sudden, like, their minds started working. You know, if we had an office in Las Vegas, the economy is booming with construction cases, and you know, you can just see the wheel. You know, are you guys thinking of moving to Vegas? Well, when we thought about Nevada, we really like Tahoe, right, in that area up there. But yeah, Vegas, you know, Raiders, they got the Raiders now. You know, they're talking the Angels moving there. And
They have the Raiders?
Yeah.
Okay.
Yes. Yes. The stadium's being built right now. When you drive down the freeway, it's right there. It's right off the freeway. So, and there's talk of the Angels leaving Anaheim to go to Vegas as well.
What's that hockey team back there? The hockey team solidified it.
Yeah. And they got I don't know what league it is, but a professional soccer team too. They have a professional soccer team out there.
My cousin lives over there, and she's married to a real estate attorney in Henderson,
Mhm.
right outside of Vegas. And he got season tickets to the Vegas Golden Knights the first year because he's a resident,
Mhm.
and he got locked in at like $5,000 a piece for each ticket. He got 4 of them,
Mhm.
and I told him the first year he got them, the first year that they started, that it was the best investment he could have made. And then they make the Stanley Cup run. The Stanley Cup, and I was just like, you. Best investment you've ever made.
Yeah, it's we were there. I've not gone to a Golden Knights game. We were there in Vegas when they were playing. And I don't know if you've ever been over there by like the T-Mobile Arena.
Yeah.
But there's this whole like courtyard area out in front that they had a band playing and they had big screens everywhere. You could watch the game from outside just fine. You're not inside with it, but it was very cool. And I was just on the outside of the stadium. And,
I haven't been inside yet either. I've been outside though. It's nice.
yeah, they've got a nice little setup there. So, who knows?
I didn't know Vegas was booming like that again. They like went down, they boom, you know.
Well, apparently, I've started reading about it now. Apparently, they have been a roller coaster economy that's been dependent on the casinos and tourism, and they're trying to turn away from that and just be a city that offers casinos and tourism, but not be as dependent on that. And you get sports teams in there, and construction is crazy. There's houses are just booming, and you get some big businesses. So who knows?
Yeah.
You know, if the firm said, "Hey, we want to open an office there and send you over," I looked at some salaries. Nevada attorneys don't make what California attorneys make. So if I could go to Nevada on my current contract,
That'd be nice.
I would be a happy guy. So I can't imagine it say, hey, we want you to relocate to Nevada and we're gonna give you a pay cut.
Right.
I can't imagine it doing that. So, but we'll see. We'll see. Right now, I'm just a member of another bar who works in California, paying bar dues for no particular reason. So tonight is review night, and I have zero insight onto how you guys feel about character evidence and the stuff that kind of looks like character evidence. Right? So I wasn't here, so I'm assuming, you know, you guys, if you have questions, we'll go through it. If you don't, I'm going to take it that you understand it. So why don't we first, let's just go through the little rule sheet. We'll hit each one. And when you look at it, there's not a lot of rules here. Okay? And we're not testing you on anything we haven't covered. So, if you look at rules 101 through 106, right? The only ones that we really talked about and you really need to have any sense about 103, rulings on evidence and preserving claims of error and what the burden is under appellate review, things like that. That's going to come up primarily in multi-states. Okay, so 103, you're going to want to just be familiar with those things for purposes of multi-states. 104, preliminary questions. Those are the hearings that you have pre-trial, where the judge makes determinations on what comes in and what doesn't come in. So keep that in mind, right? You might be asked questions about what type of options do you have, and you can say, well, I would bring this up in a 104 hearing, and the court can make its rulings. And remember, the rules of evidence don't apply in 104 hearings. The court just gets to hear everything as you present it, and the only rules that apply there are those on the privilege, which we haven't got to, so you don't need to worry about. Limiting evidence, that's more of an option. You know, you object and the court says, well, I think I'm going to let it in for this purpose. You can ask for an instruction. Say, well, Your Honor, could you instruct the jury that they're only to consider it for this purpose and not for some other purpose? And, you know, if you want to throw that in your answer when it comes in, I would object to this, and I'd ask the court to give a limiting instruction, and that's how you would talk about that. And the rule of completeness. Remember, if one side wants to offer part of a statement, whether it be oral, written, recorded, what have you, the other side has a right to offer the remainder of that statement at that same time if fairness would call for that. Okay? So if it leaves a misconception as to what may have been said, the rule of completeness is you don't have to wait till it's your turn. You can ask the court to do that right away. Questions on those general initial rules? Pretty straightforward. Not a big area. Okay, just kind of know they're there and be prepared to talk on them if it arises. 401, 403, those are your big ones, right? 401, is it relevant? Has it any tendency to make a fact of consequence more or less probable? Or however you word your rule statement, right? It's got to be a fact of consequence, and the evidence, does it make it more or less probable? However you get that combination in there, get a good rule statement, stick with it, and go. The bar for relevancy analysis is very low, right? You can come up for a reason why something would be relevant, no problem. So it shouldn't be difficult to find something relevant, but of course you're going to want to be weighing it to see if it's how probative it is on the issue, on the fact of consequence. 402, probably never mention it. That's just a general rule about relevant evidence that says when it comes in, when it doesn't, and just know that there's a presumption for admissibility of all relevant evidence. So you're never going to really cite to 402. And then 403 is going to be your headache. Right? 403 says a court may exclude evidence, not shall, not must. It may, if its probative value is substantially outweighed by its unfair prejudice, its confusing confusing the issues, it's misleading the jury, it's wasting of time, blah, 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 blah. Probative must be substantially outweighed by the unfairness. Make sure you get that order correct. Substantially outweighed is important. And even if it is substantially outweighed by the unfair prejudice, the court can still let it in, right? It says the court may exclude. Doesn't say it shall. So even if it's substantially outweighed, the court can still let it in. Okay? So 403 is going to be your big issue. Remember we talked about when you're going through your analysis, you kind of got to hit it with a 401. Is it relevant? How relevant is it? What's the issue that it's relevant towards? Go to the specific rules that are applicable. In this case, we've only got 404 through 406 are the only specific rules we've covered. So that's going to be the meat of your sandwich, and then you're going to come underneath that with a 403 analysis as to whether there's any sort of unfairness or whatnot. Okay, and that's regardless of whether you find it inadmissible, right? This is character evidence. All right, is character evidence relevant? Absolutely. Right? Is it admissible? No, 404 says it's not. Don't say this is admissible under Rule 404 and then neglect a 403 analysis. Do a 403 analysis as if it were admissible. Okay, and just state that, right? However, if the court did find this admissible under the balancing, it should still be excluded for these reasons. Okay, and right, when you're dealing with character evidence, you've got a ton of reasons why something might be unfairly prejudicial. Okay, questions on 401 and 403?
The only question I have is when you're doing your analysis and you talk about 404, so it'd be 401, then you talk about 404, then wrap it up at 403 at the end, because that's what everything's going to fall back on is 403.
Correct.
So I just want to make sure I was doing it correctly.
Yes.
Okay. Yes.
In our essays, do you want legal relevant logic? Is it legal relevance and then
Logical relevance. Logical is 401.
I know, but do you want them like both like right under each other? Because I've seen essays where they put like one and then they do like an analysis and then they do the other one.
Well, here's the problem. Okay, you can do that. All right, but let's say you find it relevant, right? And then on the 403, you say, no, this is unfair, and I would exclude it. And then where do you go? Then you go to the specific rule and say, well, notwithstanding my 403 analysis, I just said I would exclude it. I'm going to now analyze it under the specific rule, and your mind's probably at that point already predisposed to exclude it, where if you do the analysis under the specific rule, it might open you up to other issues to say, well, wait a second, maybe this isn't necessarily unfairly prejudicial, and here's why. Okay, so that's why if you can do your analysis of the specific rule first, and then you come under 403 afterwards, because that will trigger any sort of issues that you might want to evaluate under 403, going through the specific rule analysis. Okay. I've done it where I put 401 and I put 403, and then I've done a specific rule, but I didn't actually complete my 403 section until I had, I just came up and then typed above it. Because like you said, it looks easier if you got, logical relevance and legal relevance, and they're both right there. But, procedurally for the mind, I think it works better if you do the rules first and then come through with the balancing after. Okay. So.
Well, the balancing would be the very last thing that you're writing on the essay, or you're
Yeah.
underneath it too.
Balancing would be the last thing. And there should be a conclusion, right? If the question says, should the court admit this, or the court did admit this, should it have admitted it, court excluded it, should it have excluded it, don't forget to answer the question, right? Follow the call of the question. And if it's asking you, should the court have done this, well, answer it. Well, this relevant. This rule says it comes in, but under 403, I find it too unfairly prejudicial, I would exclude it. No, the court shouldn't have admitted it. Okay? Remember, there's no real right or wrong answer. What we're looking for is your ability to spot the issues and identify, is this piece of evidence probative or not on that issue, and how unfair is it, right? Not just does it point to somebody's guilt, or does it point to somebody losing their case. If it, just because it's bad against it doesn't make it unfair, right? It just makes it prejudicial. So you got to make sure you're looking for that unfairness. So more so than the answer, we're looking for the analysis. Okay. Character evidence. General rule, it's not admissible to prove that a person acted in accordance with that trait on a particular occasion. Right? There's 3 exceptions. Well, there's 4, but we've only gone over 3. In criminal cases, not in civil, in criminal cases, the defendant can offer evidence of their own trait. If they offer that evidence of their own trait, the people can rebut that trait. You say you're peaceful, people say you're violent, right? You say you're kind, people say you're mean, right? Whatever. But the people can't offer it in their case in chief. Second exception is the defendant in a criminal case can offer not just evidence of their own trait, but they can offer evidence of the victim's trait. Okay, and in that situation, the people can attack the defendant's trait and they can bolster the victim's trait. You say the victim's violent, we say the victim's peaceful. You say you're peaceful, we say you're violent. The prosecution then can do either one. Okay, note that the prosecution can do either one regardless of what you offer. Right? If you attack the victim and you say the victim is violent, and these witnesses come in and say, I've known the victim my whole life, and in my opinion, he's a violent person. I've lived in the neighborhood there with the victim my whole life, and the reputation is the victim is a violent person. Okay? The prosecution can then bring people in to say the victim's kind, gentle, peaceful, or they can bring people in to say, no, defendant, you're the violent one. In our opinion, you're violent. So you have either option there, right? You don't have to, if it's the victim's trait, you don't only get to do the victim's trait, right? You have the option of doing either one. And in a homicide case, the prosecution may offer evidence of a victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. Okay, so that doesn't necessarily have to be in their rebuttal case. It can be in their case in chief if the defense offers evidence that the victim was the first aggressor. Prosecution can bring that in right then and there. For example, prosecution calls a witness. You saw what happened, right? Tell us what happened. And the witness gives a description. On cross-examination, the defense starts asking, well, the victim was holding a knife in their hand, weren't they? Yes. And the victim was the one who actually pulled the knife out first. No. Now, even if the witness says no, the defense has already offered evidence, the possession of the knife, that the victim may be the initial aggressor. At that point, the prosecution doesn't have to wait. They can bring in witnesses to come in and say, we've known the victim our whole life. He carries that knife because he carves little horses and animals for the kids in the neighborhood because he's just the nicest, gentlest guy we know. So if they attack the victim as a first aggressor in any way. It doesn't have to be character evidence. It's just evidence that you're the one that started all this. You can then go into the trait for peacefulness. And the fourth one is that has to do with the witness's character for truthfulness. We haven't covered that yet. We'll get into that when we go over impeachment. So you don't have to worry about that for the midterm. But just know that it's there. Those are your 4 exceptions for when character evidence can come in. The only other time character evidence can come in is if character is at issue, if it's a character-driven case. And if character is at issue, then of course character evidence can come in. Right? And in the outline on character, we listed 8 or 9 instances that 7 instances that character was actually an element of the cause of action. So if you see one of those, maybe you say, hey, well, character is an issue in this case. Okay? So otherwise, it's got to be a criminal case, and the defense has to open the door somehow, some way. Okay? Let's stick on criminal evidence. Character evidence before we get into other acts. Character evidence is proven in 2 ways, primarily: reputation or opinion. And everything we've talked about up to this point is reputation or opinion. That's how you prove character evidence. If the defendant wants to offer evidence of his pertinent trait, peacefulness or generosity, he has to bring people in that can speak by way of reputation or their own personal opinion as to his character trait. That's the only way he gets it in. When the prosecution rebuts, it's opinion or reputation. You've got to lay the foundation. Do you know this person long enough? Have you heard about this person long enough to either know their reputation or to have formed your own opinion? That's how you get it in. Okay? Specific act, specific instances can be used on cross-examination. Right? Somebody takes a stand and says, I've known the defendant my whole life, and he's peaceful. He wouldn't hurt a fly. You can confront them with specific act evidence. Right? Well, did you know that he smacks his mom around? No. Well, if that were true, would that change your opinion? No. They always say that. Oh, really? So if you learn that this guy smacks his mom around, you're still going to hold the opinion that he's peaceful? Yeah. Okay. Well, right? You don't get to bring the specific act evidence in. You just get to make them look stupid because they never change their opinion. Right? And they look silly. So wait a second. You say that this guy is peaceful, you know that he beat up his girlfriend, got arrested, got convicted, got ordered to take anger management classes. If any of that were true, would that change your opinion? No. Well, what if you found out he did it to his next girlfriend? No. What if you heard that his dog had to be taken away because every time he came home from work, he was kicking? Right? And the neighbors complained about his abuse of his animal. Right? Did any of this change your opinion? No. Right? They never do. And they undermine their own credibility. But you can ask those questions. You don't get to bring in those specific instances. Okay? Yes.
Sorry, a question about that. So you're cross-examining. That's what it is, right?
Yes.
So aren't you, isn't the defense objecting to what you're asking him each time?
You can try to, as long as look. You can't just make stuff up. You've got to have a good faith belief in the questions you're asking, right? And if he has been arrested for domestic violence, and he has had to take anger management classes, and he has kicked his dog and whatnot, and you have the information, you can confront them with all of it. Okay?
But isn't that bringing it in?
Well, you're not bringing the evidence in, you're just asking a leading question. And you ask it in such a way like, have you heard? Or if you knew that this had happened, would that change your opinion? Right? So you're basically challenging their opinion with these specific acts. And, when they say, what if you knew this guy killed somebody before? Would that change your opinion? No. It looks silly, but I've had so many character witnesses through the years, and it's just such an easy cross-examination, because most defendants have dirt on their backgrounds, and most opinion and reputation witnesses just will not come off. Doesn't matter how bad this guy is, they'll never admit it. So they look silly. The only time you get into specific act evidence is if character is an element in the case, right? And I don't know what examples you guys went through. I like to pick on Bill Clinton, right? New York Times files this report. Bill Clinton is this womanizer, right? And he files a lawsuit, for defamation, right? You filed all these false reports about him. Well, truth is a defense, right? It's either an element of the cause of action or it's an element to the defense. So what does the New York Times get to do? They get to bring in all the women in. Have you had an affair with Bill Clinton? Well, yes, I have. Let's talk about that. But have you had an affair? Yes, I have. Right? You don't have to do it by reputation and opinion because now it's an element within the case. If it is, you get to bring the specific acts in. Otherwise, you don't. Okay? So when you're dealing with reputation, when you're dealing with character, it's reputation or opinion. Specific acts are allowable on cross-examination, but they're not allowable as evidence unless it's an element of the cause of action or the defense. Do not get confused, and people do, when you're talking about crimes or other acts. That's what you're talking about. Do not use the term character evidence, right? It's a misnomer. Character evidence, not admissible except in the 4 instances we talked about, the 3 defendant criminal cases and the one that we haven't covered about a witness's character for truthfulness and untruthfulness. Okay, that's the only 4 exceptions. When we're talking about crimes or other acts, it is not character evidence. Character evidence is evidence that's offered to prove that the person acted in conformity with that trait on a particular occasion. Crimes or other acts are not offered for that. They're offered for the purpose to prove motive, opportunity, intent, preparation, knowledge, all of those things, right? That's what those other acts are allowed in for. It is not character evidence, so don't call it character evidence, right? You say, well, the prosecution may seek to offer in other crime evidence to establish motive. And here's how they would do that, right? They have to have evidence of the other crime. They'd have to tie it to the defendant and have to establish a specific motive for this case, as opposed to just a general motive, right? That is when you get to talk about other crimes. People get confused all the time because they say character evidence is admissible to prove motive. It's not. It's not. Okay? Crimes and other act evidence is admissible to prove motive and intent or knowledge. Get your language straight and you won't be confused about that. Right? It is motive evidence, it is intent evidence, it is knowledge evidence, it is planning evidence, it is absence of mistake evidence, it's not character evidence. Okay? So, if the prosecution seeks to offer that, then they get to do that by way of presenting the evidence if the court allows it. If the court agrees that this evidence is probative on the issue of motive, we're going to allow you to use it. Okay? If you are, you get to use it for that purpose. Now, what is a jury going to use it for? Character. Right? The jury's going to view it as character. Oh, this guy's dirty. Once a crook, always a crook. Right? Once a murderer, always a murderer. That's how they're going to use it. That's not how you use it as a lawyer. You don't use that language. You don't argue it that way. Right? You're not allowed to argue that. And I've seen DA after DA after DA make that mistake. They win the argument with the court that this evidence gets to come in, and then they argue that it's character to the jury. You don't get to do that, right? The jury's going to do it for you, right? Let me tell you about how this guy, we know it's him, right? Who had a motive here? He did. And how do we know he had motive? Remember this incident over here? When he did the exact same thing for the exact same reason, and then this time 3 years ago, when he did the same thing for the same reason, right? And then you look over here, 5 years ago. It's the fourth time he's done this exact same thing for the exact same reason. He has the motive to commit this crime. That's how we know he's guilty here. Okay? The jury is connecting the dots, and the jury is viewing it as character evidence. But as lawyers, you can't do that. And know the difference. Don't call it character. And I've seen essay after essay after essay that says, you know, prior crime character evidence is admissible. It's not character evidence. Okay? So don't call it that. Don't use it that way. Use the proper term, and you should be fine.
I have a question. So
Yes.
if we then have character evidence, say if it's a mix of both character evidence and evidence of crimes or other acts, would we then do a second 403 analysis at the end for the crimes and other acts?
What do you mean? Like, remember, character evidence is reputation or opinion. That's what we're talking about. Prosecution can't offer that in their case in chief. Right? Defendant has to open the door. Right? They have to put that in issue before the prosecution can respond. Right? If the prosecution wants to offer crime or other act evidence on one of these allowable issues, and the court allows for it, then they put forth the specific evidence to prove that. They can call witnesses to prove it. They can offer certified convictions to prove it. They can offer videotapes, and you name it.
And most of the times they're going to find something that falls within one of these
Correct.
reasons to get
Correct.
it in for the specific.
And it's
crime.
very, very powerful evidence because the jury will treat it as character evidence. But it's a mistake for lawyers to treat it as character evidence because it's not. Okay? Identify the issue, why it would come in, and there shouldn't be any overlap. Right? If the question said something like, the people want to offer evidence that this guy's a thief, right? He's got a reputation as a thief, and they've got all these specific acts. Okay? Reputation isn't admissible, right? Unless the defendant puts it at issue. So specific acts may be admissible if it goes to identity, right? And how do we know it goes to identity? Well, if you look at the signature type way he committed these crimes, all of these thefts were committed this particular way, it goes towards his identity as a perpetrator. Okay, so then yes, I mean you could do a dual type analysis if it asked you, but that's actually asking you about two separate pieces of evidence.
Right, so I guess my question is then, if you did have two separate pieces of evidence, you would do your analysis on the character evidence and fall back on 403, and then you would do your analysis of the past crimes or other acts, see if it fits into one of these ways. Even if it does, you would still fall back on another 403 analysis, correct? Okay.
Yes, yes. So treat those separate pieces of evidence separately, and make sure if you're talking about prior instances, just stay away from calling it character. As soon as you call it character, it twists your mind in thinking it's character. Like, wait a second, what's that rule? Well, character is opinion and reputation, but the DA wants to offer this in. I don't think they can. Wait a second, what's that exception? It's not, just don't think of it as character, because it's not, right? It's being offered for some other admissible and allowable purpose. Okay, and then the last thing is habit, right? 406, right? Character is something that you do most of the time. Habit is something that you do all the time, that you do every time. Habit evidence is admissible. So if you want something in the evidence, you don't want a character evidence, you want it labeled as habit. You want to try your best to demonstrate that they do this every time, period. And if they do it every time, it's habit and it's admissible, period. Okay? If they only do it some of the time, it's character and it's not admissible. Yes?
What if they do it not, what if they do it not all the time, but what if it's like 85% of the time? It's really who they are, if they do this. Maybe they missed one day of brushing their teeth at 7 o'clock in the morning, whatever, but most of the time they do it. Does that still have it?
Then you got to make your argument,
Okay.
right? Look, this guy has woken up at 7 a.m. for the last 40 years, and he gets up, throws water on his face, brushes his teeth, and goes out and starts his coffee. He does it every day like clockwork. There have been days during those 40 years when he hasn't, when he's been out of town, when he's, whatever. Of course, there's going to be those exceptions. You're going to have to draw the line, just like the court would, because the rule doesn't. Is it habit or not? Right? Courts don't like habit evidence, just like they don't like character evidence. So if you give them a reason to call it character evidence, they will, and they'll exclude it, right? Because habit evidence is just as powerful as character evidence. It can be just as unfair. So if you want to get it as a habit, make sure that your argument is they do this every time, period. If you give any wiggle room, the court's going to come off. Okay. Questions about character evidence and crime and other act. It's important that you note that it's other act. It doesn't have to be a crime. It can be just another instance, another something that happened. You don't have to be arrested. You don't have to be charged. You don't have to be convicted. Most likely, it's another crime and it's used in the criminal context because the only person who can use this is the prosecutor, right? This doesn't allow for you to use it in a civil case. So, though there are some states that are moving towards allowing these type of exceptions and whatnot, and tort cases that involve like intentional torts where it's borderline criminal anyway, or maybe it is criminal, but you're just suing civilly for it because they've already been prosecuted for it criminally. So, you guys want to look at an example? Any of you do the essay? Did you try to do the essay?
Until today.
I didn't see
Not yet.
Well, let's go through it. So you can kind of see how this works out. Okay? In a murder prosecution, here's my advice to you. As you see things that are important, note them, but don't note them so that your whole page is noted, right? If it's important, note it, okay? Right now, you have a very good chance that this essay is going to cover what? What do you guys think is going to be on the essay? Character evidence, right? Other crime evidence. That's the only substantive rule we've covered up to this point, right? So you've got a very good chance that character evidence is going to be a topic on your midterm essay. Okay? We're not, you've got a good shot at that. Okay? Part of the exceptions in the character rule deal with criminal case exceptions, right? Note that. In a murder prosecution of Doc, criminal case, right? It tells you right out the bat, this is a criminal case. For the shooting death of Vic McRustler, assume the following factual scenario. So that first sentence tells you one important thing. It tells you that this is a criminal case. Doc, he's a drifter with a shady past and a reputation as a killer. Character evidence, reputation, I'm highlighting that, right? He's got a shady past and a reputation as a killer. Do you know if it's going to come up? Nope. But you know that character evidence deals with reputations and opinions. So if you see that word, I'd highlight it. Okay? He resides in the dusty frontier town of Grave Rock. Vic, a cowboy, right? He's going to be your victim. Real original names here, right? With a reputation in the town of being a cattle rustler. Again, another reputation. The victim has a reputation too. Okay, and he lives in a ranch just outside of town. His numerous incidents of rustling make his reputation well earned. So now you know you've got some prior incidents of cattle rustling. However, he is known by his friends as a peaceful, loving sort. So his friends will come to tell us, it's a reasonable inference that they're going to say, our opinion of him is he's peaceful. Right? You should be able to draw that conclusion from reading this. So Doc's a killer with a shady past. Vic is a cattle rustler with numerous incidents of rustling, and his friends will say he's a peaceful, loving sort. Okay? A lot of information in that first paragraph. In the days leading up to the shooting, Vic was overheard by numerous people threatening Doc and his friend Marshall Earp. Now, I'm just going to point out to you, for purposes of our midterm essay, there's nothing really there, right? But Vic was overheard. In your final, you might be saying, wait a second, hearsay. People heard him say that, right? You've got to be looking at the facts, because the facts are going to tell you what rules you can pull from and use. So you've got to identify the rules through the facts. Reputation tells you maybe this is character evidence, right? Overhearing things and statements from other people tells you maybe we're talking hearsay, okay? We haven't studied hearsay. It's not on the midterm, but I just point that out, that identifying the issues for the test goes a long way. If you miss it, you're not going to know which rule to apply, right? You can know all the rules you want, but if you don't know when they apply and what facts implicate them, you're going to be lost, okay? Marshall is the lawman of the town, and he's charged with enforcing the laws and maintaining the peace. He's been trying to make a case on Vic and his fellow cowboys for years, leading to Vic's dislike of Marshall and his friend Doc. Tipsy LaRue, the local bartender, overheard Doc say the day before the shooting, Vic is a low-down, no-good scoundrel. Doc then laughed and added, nah, I'm just kidding. Grave Rock has an ordinance that prohibits the possession of firearms within town proper. Vic was seen armed the morning of the shooting and overheard continuing with his threats to get Marshall and Doc. You haven't even read the question yet, but knowing that character evidence is going to be a potential here, and knowing that there's criminal exceptions, and one of those exceptions is implicated if the victim is identified as a possible initial aggressor. You don't even know what the question is asking, but you should be able to identify, wait a second here, this is saying Vic is armed, right? He's threatening people. Whisker Trimmer, the local barber, tells Marshall and Doc what he has personally seen and heard, specifically Vic with a gun and Vic's threats. Whisker's nickname is Whiskey because of his affinity to drink all day, every day. Marshall and Doc confront Vic at the All Right Corral. Marshall tells Vic to turn over his gun. He reaches for his gun in an aggressive way, and Doc shoots him with his shotgun in the chest. There's your facts. Okay? At Doc's trial, the following occurs. In pretrial motions, i.e. 104 motions, okay, the prosecution seeks to introduce Doc's shady past and reputation in her case in chief. Defense objects under the U.S. Constitution, the state constitution, any and all applicable statutes and cases, and just the plain unfairness of it all. The prosecutor argues this information goes to intent and absence of mistake, lack of accident under Federal Rules of Evidence 404(b)(2). How should the court rule and why? There's a lot in this question. Okay, and it kind of goes to Daniel's point. You're not going to do one analysis here, right? You're going to do a whole bunch of analysis here. Okay, so let's just go through it, right? The prosecution wants to introduce Doc's shady past and reputation in her case in chief. Is Doc, is his shady past, is that relevant? What does it mean that he has a shady past? Right? It seems like it would be relevant. It would make it more or less probable. But what is it? Right? It seems to be probably a little too vague. It's not reputation and opinion. Right? So it's not character evidence. It's really hard to analyze, and that's okay for an answer, right? It's hard to analyze whether, what shady past means, right? Does it mean he acted shady in conformity with his shady past? So I would say that his shady past is too vague to analyze, though it would appear relevant as it would tend to make the fact that Doc killed Vic a fact of consequence in determining the action more probable. Okay, then you go to Doc's reputation, and what's his reputation? He's a killer. That's his reputation, right? Is Doc's reputation as a killer? It's clearly more specific. Is that relevant? Would it make it more or less probable that Doc killed Vic? Absolutely, right? So then you go to 404. B2, this question gave you the rule. If you know the rule number, great. If you don't have to use it. If you use a rule number, make sure you're using the right one. Okay? So the people want to introduce this. They say that this goes to intent, absence of mistake, lack of accident. Okay? So what does 404(b)(2) allows? It allows for the introductions of crimes or other acts for proving intent and absence of mistake and lack of accident. As presented here, though, right, there's not enough information to admit this evidence. Right, the court's got to be satisfied that, right, the facts support the conclusion that it goes to intent and absence of mistake, lack of accident. And that evidence is what? When you're offering that evidence, you're offering specific acts, right? You are not doing that by way of reputation, right? So if you wanted to prove that he was a killer, and you wanted to prove that these prior acts of killing go to his intent and absence of mistake, lack of accident, you would be offering the specific act evidence of those killings. You would not be offering the reputation as a killer. Okay? So, under 404B2, as presented, offering reputation evidence is not appropriate under the 404B2 exception, right? But assuming the prosecution gave proper notice, and assuming the prosecution has witnesses to the specific acts, right, the court may find that it's admissible, but only after conducting a 403 analysis, right? The use of Doc's past and his reputation as a killer are highly prejudicial. They run the risk that the jury might rely on them to convict Doc based on those facts rather than the evidence of him actual killing Dick in this case. Okay, so just a nice little transition sentence gets you into 403, right? Under 402, you've already come to the conclusion that it's not admissible. The court should exclude it. However, if the court found that it was admissible because there were witnesses or whatnot, it still has to do a 403. And then under 403, you do that analysis, you do that weighing. Right? Is it probative? Yes. How probative? Well, reputation as a killer, probably pretty probative, right? Is it prejudicial? Sure. Jury finds out you've killed somebody before, they're probably going to convict you of killing this guy, right? So highly, highly prejudicial. And since at this point the facts say it's based on reputation alone, the court should exclude it because unfair prejudice is substantially outweighs the probative value. My analysis. You can come to a different conclusion, but that's how I would answer this. Okay? Some of you might have been looking, well, wait a second, that objection's all wrong, right? He's talking about the U.S. Constitution, state Constitution, any and all statutes. And saying that's a very broad objection. And we talked about objection in class, right? And that's not specific. Doesn't do a good job of preserving, right, the record on appeal, and the court can't really rule based on that. If you had thrown in a statement about the objection, nothing wrong with that. Okay, kudos for extra points. The question is, how should the court rule? You could say, well, the court could rule that the objection is inappropriate for these reasons, but ultimately, whether the evidence should be admissible or not is a 401, 404, 403 analysis. Okay, so that's just kind of thrown in there. If you saw it and you wanted to comment on it, some extra points there, but that would not preclude the analysis that follows. Okay, questions on number one? Everybody, you got it, you see it. Okay. At trial, the prosecution tends to call Slice you up, the town coroner. Slice is prepared to testify about the manner and cause of death, as well as to bring in the lone photograph depicting a badly mangled body of Vic. What must happen before Slice testifies? That's the first question. Now you can keep reading, but at some point there's going to be an expectation that you answer that question, right? I've seen people just keep on going, right? Defense objects to the use of a gruesome photograph. Prosecution asserts that it is not simply the only evidence available to demonstrate the nature and callousness of the crime, but it's also the most accurate. How should the court rule and why? And you jump into the analysis of whether the gruesome photograph should be allowed, and you forget to answer what must happen before Slice testifies. Right? What rules have we covered that deals with what must happen before Slice testifies?
Relevance.
Covered relevance. Is it relevant? Him testifying to the cause and manner of death? Yes. What else should happen?
Let's lay the foundation for bringing in the photograph.
Well, you got to lay the foundation, but this is before he testifies.
Oh,
Right? We haven't. We've got rules 101 through 106 and 401 through 406. Now, we haven't talked about expert testimony, but we have talked about Rule 104 hearings, preliminary questions of fact. That's where the court makes determinations as to not only who can testify, but what evidence will be admissible if you bring it to their attention. Before Slice will be allowed to testify, there's going to have to be a 104 hearing to determine whether he's competent and qualified to testify as an expert. Okay, we haven't talked about expert opinions. Okay, so this is kind of a throwaway question, but it's an important one because we've covered this rule. So what's got to happen? You don't have enough information to determine whether he's qualified or not. And we haven't even covered what makes him qualified or not. But you have enough information in what we have studied before he testifies. There's got to be a pretrial hearing under 104 to determine the preliminary question of whether he will be allowed to testify as an expert. And the court makes this determination. This is up to you, how involved you want to get with it. Right? The court makes this determination by hearing evidence and argument on the issue, must be convinced by a preponderance of the evidence, and the rules of evidence do not apply to that hearing. That's all stuff we've covered, right? That's a A+, excellent 104 answer, right? You're not answering whether he's qualified as an expert. You're answering the question, what must happen before he testifies? Okay? So if you see something like that, stop, highlight it, don't forget to answer it, because you get wrapped up in everything that happens next, and then you forget to go back and answer the question. Hey, wait a second, what was supposed to happen before Slice testified? I didn't mention it. I just got 0 104 points on my essay because I didn't even bring it up. Okay, but that's how 104 will come up. This piece of evidence, you know, somebody wants to introduce this piece of evidence. What should happen before it's admitted? Right? If anything like that, any type of question like that, that should be a clue we're looking at 104. Right? Judge makes a determination, he hears the evidence, he hears the argument, he uses a preponderance of the evidence, and rules of evidence don't apply, except for privilege, and we're not there yet. Okay? So, defense objects to the use of the gruesome photo, right? Is the photo relevant? Clearly, right? It's probative of how the victim died. It's a fact of consummance. It makes it more probable that Vicks was shot with a shotgun as alleged. Okay? Is it prejudicial? Right? Well, we can't see it, but it says it's a badly mangled body. Right? What makes it prejudicial? Is it prejudicial that because a jury might decide the case based on emotion rather than the facts of the case? That's the danger, right? That they're going to base this decision on the ultimate issue of whether Doc murdered Vic on this emotion rather than on the other facts. Okay, so how unfair is that? There's only one photo, so the court doesn't get to say, well, I'll let you use one and not the other. Okay, how probative is it? You got to weigh it. I'm going to say it's highly probative. How unfairly is it? Doesn't matter. I said it's highly probative. If I say it's highly unfair, I'm still letting it in. Right?
Substantially over.
Right. If I say it's somewhat probative, highly unfair, all right, then maybe your questions, your answer should say something like, I think I might exclude this. Right? Put a label on it that will help you identify how much weight you're putting on either side. If something is very probative, it doesn't really matter how unfair it is because it's going to have to be really, really, really unfair to substantially outweigh it. There's only one photo of what happened to this guy, and that's the most probative issue on what actually happened to him. Right? We've got evidence of a mangled body. Is that consistent with shotgun's blast? Or does it look like he got stabbed a whole bunch of times and wasn't even a shotgun? Right? It's very probative, and that's how I analyzed it. So the picture is just a relevance, prejudice, and then balance them out. Okay? However you get there. Questions on number 2? You got it? All right, number 3. At trial, the prosecution offers into evidence the testimony of Tipsy. She asked Tipsy the following. Isn't it true that Doc said Vic was a no-good, low-down scoundrel? How should Doc's lawyer respond? We've spent a lot of time talking about objections and how you respond. Okay? So we're at trial. The prosecution is offering Tipsy, and the prosecution says, isn't it true that Doc said Vic was a no-good, low-down scoundrel? I want to hear hearsay because we haven't covered it yet. What we have covered, what do you see here?
Did you not differentiate whether it's direct or cross on purpose?
Well, what do you think it is, right? The prosecution is offering Tipsy's testimony. So any questioning that they do of Tipsy is what? It's either direct, redirect, re-redirect, re-redirect. You're never going to cross-examine your own witness. Okay? So it's hidden in there, right? You're on the right track. Prosecution is offering Tipsy. So they are directing Tipsy. And your objection is?
Lead.
Absolutely leading. What else you got? What's the prosecution trying to do here?
Compound question, because it's 3 different.
Well, it's not really a compound question, right? They're like, isn't it true that Doc said this?
Yeah.
Right? Vic was a no-good, low-down scoundrel.
Here's
So yeah, it might be hearsay, but we're not there yet. So what's the prosecution trying to do? They're trying to present a statement of Doc a certain way. What did Doc say? And
Oh, then it's no, I'm just kidding.
exactly, then he laughed to no, I'm just kidding. Right? Prosecution's offering part of a statement to give a perception as to what Doc may have said.
What would
Right.
that- What would that be? What would the objection be?
So I would object on 2 grounds. Right? The prosecution's asking leading questions, and the prosecution's only offering the evidence part of Doc's statements. Okay, we haven't got there yet. I mean, we kind of did early on, but we didn't really cover it. Right? Rule 611C says leading questions can't be used on direct examination. You don't need the rule number. Just know that you don't get to lead your own witnesses unless they're hostile and whatnot. So in this case, that was meant to jump out at you. The prosecution is asking a leading question to their own. And the second part is they're offering part of Doc's statement. Rule 106 allows an adverse party, here Doc, to require the introduction of the remainder of the statement that out of fairness the court determines should be heard. So if I'm the defense, I say, well, the prosecution's only offering part of this, Your Honor. I think the jury is entitled out of fairness to hear everything he said. Court says yes, court says no, court says what have you. Okay, now notice the call of this question. How should Doc's lawyer respond? It doesn't tell you, should the court allow it in, should the court not allow it in. This is a question about objecting and putting the issues before the court. Is the court going to let the rest of the statement in? Doesn't matter. You don't have to analyze that. If you're Doc's attorney, objection, Your Honor, he's leading his own witness and he's not offering the whole statement. And 106, out of fairness, says they should be allowed to hear the rest of the statement right now. You know, whether the court rules and agrees with that's fine. Doesn't matter. You don't have to analyze it. But if you're Doc's lawyer, those are things that you should be looking for to put out there. Okay? Questions on that? 3, short and sweet. Okay? Short and sweet. And I'm telling you, don't get caught up on stuff we haven't covered. Don't think you know stuff that we haven't covered. If we haven't covered hearsay, that's not the answer we're looking for. Okay? There's something else in there. So, 4. At trial, the defense calls Whisker to testify about what he saw and heard. Namely, that Vic was armed and making threats towards Marshall and Doc. Prosecution then asked Whisker on cross-examination the following 2 questions. Isn't it true that 2 years ago Doc was dating a prostitute? And isn't it true that when Doc was a boy he once kicked a puppy? How should Doc's lawyer respond to each of these questions? So let's take that first. Okay, defense calls Whisker to the stand, right? And they're asking him questions about the Vic being armed and the Vic making threats, right? Type of questions that go towards maybe the Vic was the initial aggressor, maybe Doc was acting in self-defense, right? That's where that type of evidence is headed towards, and that's consistent with our 404 rules where maybe that plays a role or not, okay? And then he asked 2 specific questions on cross-examination, right? Here the prosecution is allowed to lead, okay? So I would analyze these separately. Don't analyze them one at a time, okay? The first question, isn't it true that 2 years ago Doc was dating a prostitute? Okay, first, he should object that any question about Doc dating a prostitute 2 years prior is irrelevant. right? What's the relevancy of him dating a prostitute, right? It's just to try and dirty him up, right? And that's not, Vic hasn't offered um, a reputation testimony yet. Arguably, he's offered testimony that the victim was the initial aggressor. And if that's the case, what does the prosecution get to do? They get to offer evidence that the victim was peaceful, right? That's what they get to do. So is it relevant? Make your argument. I say the prosecutor isn't relevant. Relevant evidence requires that it have any tendency to make more or less probable a fact of consequence. Who he dated 2 years prior does not address a fact of consequence. 404 A1 and 405. Doc's lawyer should object to the improper character evidence that as a boy he kicked a puppy. Not only is this prohibited under Rule 404 as improper character evidence, it is also not permitted under 405, which prohibits testimony of specific acts except under certain circumstances. The proper method of proving up character would be by reputation or opinion. Doc's lawyer should also argue this is irrelevant and under a 403 analysis very prejudicial. Okay, so having not, and it's up to you how deep you want to go. Okay, he's asked about the prostitute. To me, that's just completely irrelevant, right? That's an attempt to offer character evidence, specific evidence, which isn't allowable and very prejudicial, shouldn't come in. Secondly, he's asking about Doc when he was a boy and he kicked it, right? Is that relevant? Maybe it's relevant to an act of violence, but even if he's opened the door saying the victim was the initial aggressor, Rule 404 prohibits this type of evidence, right? 404 says the prosecution gets to offer evidence of the victim's trait of peacefulness, and they can only ask specific at cross-examination to a character witness. So if Whisker was here talking about, in my opinion, Doc is peaceful, Doc's reputation around town is he's nonviolent, well then that might be an appropriate specific question to him. But because he's not a character witness, specific at cross-examination is precluded. You don't get to go into that, right? Because you're in essence offering character evidence by suggestion through the question. Okay, so it's up to you how deep you want to get into that, right? By suggesting that Vic was armed and making threats, right? And inference can be drawn that he was violent. It can also be drawn that he was a first aggressor. An exception is implicated here because it's a criminal case. The prosecution can now offer evidence to rebut this by calling Vic's Cowboys friends to testify about his reputation for being a peaceful, loving sort. Okay? So how should the Doc's lawyer respond? He's objecting. It's irrelevant. It's improper given the state of the evidence. Are there more appropriate lines of questioning the prosecution should be undertaking? Okay. And what option does the prosecution have after Whisker's testimony? Right? The more appropriate lines of questioning they should be undertaking. What's Whisker's nickname? Whiskey. Right? And why they call him Whiskey? He drinks all day, every day. Right? So probably a good line of questioning with Whiskey would be his ability to observe and recall the events and whether or not he was intoxicated at the time this happened and whether or not he was intoxicated at the time he's testifying. Right? That's an appropriate line of questioning. Right? And what option does the prosecution have after his testimony? Well, it has the option of calling character witnesses to testify about the victim's trait for peacefulness. Does he have that? Yeah, the facts tell you that all of Vic's friends say he's a peaceful, loving sort, right? So as soon as Whisker testified and opened the door by saying that Vic was armed and making threats, if I'm the prosecution, I say, Your Honor, I think he's opened the door, and I get to rebut that with testimony of the victim's peacefulness. And I'm going to do that by calling all the cowboys to rebut that claim. You see it? I mean, this question, it has a lot in it, and it's asking you to do a lot of separate analysis, but the analysis is the same that we keep talking about if you do it step by step, right? Is he a prostitute? Is it relevant? I didn't even get over the relevancy hurdle with that, okay? You could argue, yeah, if you're with a prostitute, you're a criminal, and all criminals are that. It's a stretch, okay? Does he kick the puppy? Is it relevant? Not really. Is it appropriate? Well, where are you and what type of evidence has just been offered and what are you allowed to do? So understanding the rules, that Whisker isn't a character evidence, it isn't a character witness. He's not offering his reputation or opinion testimony. He's saying, here's what I saw and here's what I heard. He's just a plain old witness. So a plain old witness, you don't get to ask that type of question to. This sort of specific act. Did you know, have you heard type question, okay? So it's just inappropriate at that point. So how should you respond? Object to both. Lay out your objections, okay? What's the appropriate line of questioning? Think about it, right? If Whisker's up there, what are you gonna do? Remember, we're a trial academy here, right? Whisker's on the stand, right? He's saying this stuff. You wanna undercut his credibility. It's the easiest way to do it.
Show that he's a drunk.
Show that he's a drunk, right? That fact was given to you for a reason, right? Show that he's a drunk, right? And then what does the prosecution get to do? Well, identify what it is that Whisker just did, right? How do you demonstrate that somebody was an initial aggressor? By this type of testimony, right? This wasn't direct, right? It could be he called Whisker and Whisker said, I saw Vic punch Doc first. Okay, clearly he's the initial aggressor, and that's what's it's offering. This is showing you in real life the subtleties that you might be faced with, right? Did he say he was the initial aggressor? No. But did he say he was the initial aggressor? He absolutely wants the jury to infer that he's the initial aggressor. That's why he's saying he's armed and making threats, right? That's why the defense is offering this evidence. So if they do that and you're the prosecution, what are you going to do? You're going to do what the law allows you to do if you can, right? This says, you know, the prosecution can offer evidence of the victim's trait for peacefulness to rebut evidence he was the first aggressor. Well, what if nobody will come forward and say the victim was peaceful? You can't rebut it then, right? The rule is very specific how you get to rebut this type of evidence. But fortunately for you, our facts provided you just such evidence. If you remember way back when, right, that it said his friends know him as being peaceful. And so they would come and they would say that. And we just got done with that in like 45 minutes. You guys got still time to spell check and proofread, and you know you're not even worried yet. Okay. Questions about the essay? Okay. Read the call of the question. If it asks you, should this be excluded? Should this be admitted? How should the court rule? Do your analysis. Relevance, rule, balancing. If it asks you, how should the lawyer respond? You're asking me objections. And are there rules that allow me to do stuff in this type of factual situation, right? Can I argue 106 is implicated, right? Can I point out that it's a leading question? Can I point out that it's argumentative or whatnot? Right? All of the stuff that we kind of covered, we don't expect you to be masters of objections, but in this case, it was kind of served up like a softball, right? How do you know something's leading? Isn't it true? Right? That's the key to a leading question. What must happen before a witness testifies, or what must happen before a piece of evidence is admitted? That's asking you a procedural question, which should prompt you into 104 thinking, right? Maybe how should the lawyers respond? And involves requesting for a limiting instruction, right? Take the facts that are given to you, use the rules that we have covered up till now. Don't go digging for other rules. We're testing you over what we have covered to this point. Okay? So no, 404 is a nasty, nasty rule, right? There's a lot of ins and outs there. Not just the exceptions are easy, right? Criminal case, defendant opens the door for himself, the victim, or in a homicide case, the victim's the initial aggressor, right? What can the prosecution do? But what type of evidence do you get to use? It's opinion, it's reputation. What about specific act? Well, only if it's an element of the crime, right? But what if you want to ask specific cross-examinations? I remember you got to do that, right? Well, yes, if it's a character witness. You don't get to ask specific act questions to dirty up somebody to any witness. You only get to ask those questions to a character witness. Whisker wasn't a character witness, so you don't get to do that with him. Okay? You've got to identify and pick up these little details that are contained within the rules, and you should be fine. Okay?
Would you, on an exam, are you going to distinguish whether it's a character witness or whether it's, or are we supposed to figure that out?
You have to figure that out. Right? And it's real simple, right? Whisker was called to testify to what he saw and heard. That's telling you he's not a character. Whisker was called to testify about his opinion about, Doc, or about what he knew of Doc's reputation, right? They're going to have to tell you what he's being called to talk about. If he's a character witness, it's opinion and reputation. I'm just so you guys know, I know it's after 7:30, but we're almost done. I figured we'll stay here for 5 more minutes and answer your questions, or you can take a break and then come back in 15 minutes and we'll answer your questions. But this is, it's not easy. The key is you've got to know these rules. That's the easy part. Once you know the rules, then you got to see how they fit the facts. That's the difficult part. Okay? So remember knowing what the rules are and then just identifying them as you go down. wait a second, reputation, ooh, that's important, right? Oh, here's another reputation here. Oh, he's a drunk, right? Just looking for and identifying those sorts of little factual nuggets can make or break your analysis, right? Because if you draw the conclusion that whiskey was a character witness, right? Your analysis is, yeah, you're allowed to ask specific questions to character witnesses. I would allow it. Yeah, prosecution gets to ask them about kicking puppies, right? But when you think about it, even if Whisker was a character evidence, that's not a good specific act question. Isn't it true when Doc was a boy he kicked a puppy? That's not a specific act cross-examination question, right? That's well, if you had known that Doc kicked puppies when he was little, would that change your opinion of him? Right, that's how that works. How do we even know Whisker knows what Doc did when he was a boy? So I am done with my presentation, guys. Questions? Hit me now. You got our emails. I'll answer emails up until Friday. Saturday morning, no email askers. So if you have questions, you can send us an email. We'll respond. We'll answer them for you. Okay.
I guess the one thing real quick that is the cross-exam part. Not specific acts. The puppy, he was on cross-exam. Prosecution then asked Whisker on cross-exam, blah, blah, blah. Isn't it true she kicked a puppy who dated a prostitute?
It's wrong on two fronts.
Okay.
The first way it's wrong is Whisker is not a character testimony. He's not offering character testimony.
Okay.
He's not saying, in my opinion, Doc is peaceful, or his reputation is peaceful, right? So he's not a character witness. So just imagine that, right? You're called to the stand. So what did you see? I saw that red car just blow through the red light and it hit that blue car that was going on a green light. But isn't it true that the driver of the blue car kicks puppies? What? That's not an appropriate line of questioning to just a person who's offering what they saw or heard. Okay? If he is a character witness and he's there to say, in my opinion, Doc's a peaceful guy. Known him all my life. In my opinion, he's a peaceful guy. Then you can ask him specific acts to see if it would change his opinion. Would it change your opinion if you knew that when he was a boy, he kicked puppies? Right? Not, you see the difference between that and isn't it true he kicked puppies when he was a boy?
Right.
It doesn't matter if it was true if he would kick puppies when he was a boy. What matters is, if it were true, would that change your opinion? And if it wouldn't change your opinion, that's really what we're getting for. What we're getting at is you're trying to present them with specific instances to see if that would change their opinion. So your question has to be formed that way, right? You don't just ask them, isn't it true he did this? You ask them, if it was true, would that change your opinion? And so that's wrong on two fronts. That's the way it went down. Anything else? Okay.
I feel like it would be easy. You said you have to kind of gauge on how deep you want to go. It could be easy to run over your time and get caught in the weeds analyzing something too much and not moving
Right.
on.
And some stuff is simple, right? Like that first one, what was it, number 3, right, was just real simple, right? How should the defensive respond? That's, he's leading his own witness and he's not giving the full, complete statement. Okay, done. Move on, in and out. Okay? Some of the rules we're testing are like that, right? You're not gonna have a full character rule analysis on every question, okay? But you're gonna have some, right? You're gonna have some that's talking about the character rules, you're gonna have some that talk about the exceptions, and so know your rules and then identify when they come into play. And if you read a question, don't bypass it to read the rest of the question. Make sure you know to answer that question, because there may be multiple questions within each number. All right? Okay,
Thank you.
let's find out who's beating who.
The Red Sox are winning.
Are they?
I don't know, I'm just assuming.
It was 2-1. Red Sox were winning when I got here.
Who's pitching tonight for the Dodgers?
Kershaw,
Didn't he just pitch on Sunday?
just the ninth inning, yeah. Yeah, he closed. So it's wow. It's 5-3 Boston. Both starting pitchers are gone. 5-3, bottom of the 6th. All right, guys. So we are done. Good luck on Saturday. I like to come and see you guys Saturday at lunchtime, just in time for the food, and then I will be grading while you work on your multi-states. So.
And multi-states, they're only 20 in the midterm.
Yeah.
Each class.
Yeah.
20 in class.
And if you don't see me on Saturday, maybe because I won. I ain't grading those stinking midterms. Billionaire.
But you just looked at the bottom 4, you gotta at least spend some time to look at the
So that's how you get yourself killed though, because if you go out of the normalcy of your life after you win, people know.
Exactly.
Ooh,
Yeah, it was funny. I read a little article today on it's like 5 tips for winning the lottery, and one of them was like leave town for a month. Say nothing. Just tell your friends you're taking a vacation. Leave for a month. Just get your head on straight. Wrap your mind around everything. Get your financial team in place, and don't tell anybody, because as soon as you tell somebody, it's on.
Yeah.
I'll be in here dancing.
Are you guys ready? Oh, I just passed the bar.
Need some autographs?
Oh, yeah.
no, it's just the color.
Oh.
I don't like it.
All right, guys. Good luck.
Thank you.
Sure it'll be a piece of cake for you guys. You only got a little bit to study.
Yeah.
You can see now there's a lot to cover in there, but you know what's coming. So you ready for it?
We'll survive.
Yeah.
Before.
What was it?
Oh, because it's just like, I was just feeling overwhelmed.
Overwhelmed.
Yeah, with how
With the-
much, and if you don't have the rules down,
If you
like,
don't have
oh,
it, you're
you're done, you're
You're
done.
done.
Yeah, for this class.
For this class, yeah, well, yeah, you're done, there's no,
Right.
It'll be
you can't.
Right, you
fumble.
can't, right.
Well, there's not enough
Nothing
time to be fumbling around with the rules, kind of like
Yeah.
on a baby bar, you just can't, you have to have them committed to memory.
Right.
And if you don't,
Well, I'm glad that there's a lot more like clear cut rules, you know, now.
yeah,